Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study case law number 42/2021/AL regarding the right to select a competent court to resolve the consumer's dispute, while there is a term of arbitration in the model contract. We'll start with the source of the case law, the overview of the case law. Then we'll move to the content of the case, assessment of the court, and finally, the rules from the case. The case law was adopted by the Judicial Council of the Supreme People's Court on February 23, 2021 and promulgated under Decision No. 42/QDCA on March 12, 2021 of the Chief Justice of the Supreme People's Court. First Instance Verdict No. 54/2018/DSST dated November 16, 2018, of the People's Court of Nha Trang City, Con Hoa Province on the civil case of dispute service contract between the plaintiff, Mrs. LUient T and Mr. Nguyen Hong S with the defendant, the Tourist Company, Ltd. The situation of this case law is as follows. In a model contract concluded with a consumer, there is a clause to select a foreign arbitrator to settle the disputes. When there was a dispute, the consumer filed a lawsuit at a court in Vietnam. As for the legal solution, in this case, it is necessary to determine that the consumer did not select the arbitration and is entitled to select a court in Vietnam to settle the dispute. The legal provisions related to this case are Article 38 of the Law on the Protection of Consumers' Rights 2010, Article 17 of the Law on Commercial Arbitration 2010, Clause 3 of Article 26, Clause 1 of Article 35 of the Civil Procedure Code 2015, and Clause 5 of Article 4 of Resolution No. 01/2014/NQHDTP dated March 20, 2014, of the Judicial Council of the Supreme People's Court, guiding the implementation of a number of provisions of the law on commercial arbitration. The key words of the case law include model contract with agreement on selection of foreign arbitration, consumers, and selection of Vietnamese court. Next, the content of the case. According to the petition dated December 8, 2017, the self-declaration, the plaintiff presented that on February 26, 2017, Ms. Nguyen T and Mr. Nguyen Hong S signed vacation ownership contract number PBRCS 0646221 with the Tourist Area Company, Limited. Accordingly, the value of vacation ownership contract is 388,110,000 VND, week off was week 16, and type of apartment was type A. As of March 15, 2017, Ms. Nguyen T, Mr. Nguyen Hong S made a deposit of 300,488,000 VND. At the time of concluding the contract, due to the limited time, Ms. T and Mr. S did not read carefully the signed contract. On April 26, 2017, after receiving an email from the Tourist Company, Limited, Ms. Nguyen T, Mr. Nguyen Hong S carefully reviewed the signed contract and found that there were some unreasonable terms of contract. Thus, they actively proposed to terminate the contract, but the Tourist Company Limited didn't agree. Therefore, to protect their rights and interests, Ms. Nguyen T and Mr. Nguyen Hong South sued at the court to request the court to declare vacation ownership contract number PBRCS 0646221 days February 26, 2017 is invalid and asked for being paid an amount of 300,488,000 VND for the following reasons. First, Tourist Company V deceived customers like opening a seminar on tourism but did not implement the content of the seminar program. Second, Tourist Area V Company, Limited advertised products designed according to the model that was awarded the Asia Pacific Award. However, when built, it was different from the advertised model. Third, Tourist Area Company V violated the prohibition of the law that a foreign invested enterprise is not allowed to send Vietnamese abroad and dispose of a deposit when not in your possession. And fourth, progress of construction and official operation of the project was slow compared with their commitments, causing the damages to those who purchased vacation ownership. The defendant disagreed with the reasons given by the plaintiff based on the following points. 1. It was a false judgment based on the plaintiff's subjective opinions that the company deceived the consumer. The company claimed not to fabricate or provide false information to consumers. 2. At the introduction, the company clearly explained that this is a vacation purchase, not a real estate purchase, so there was no confusion about the contract. 3. The company did not bring customers abroad. The fact was that if the resort customers did not like to stay domestically, they can exchange vacations with other customers to go abroad. 4. Regarding the deposit amount, agreement on the use of the deposit is not restricted by law. The purpose of using the company's deposits was not against the law. And 5. The construction progress and the official opening date were clearly specified in Article 8 of the contract, which was 36 months from the date of issuance of the last construction permit of the project and was entitled to an extension of 6 months. Findings of the court. After reviewing the documents in the case examined and based on the argument results at the court hearing, the trial panel finds out that the legal dispute was defined as service contract as defined in Article 513 of the Civil Code 2015 and Article 14 of the Law on the Protection of Consumers' Rights. At Clause 12.3 of Vacation Ownership Contract, the parties agreed to choose the Singapore International Arbitration Centre (SAIC) as the agency and method of dispute settlement. Article 17 of the Law on Commercial Arbitration and Guidance in Clause 5, Article 4 of the Resolution No. January 2014/NQHDTP stipulates that the arbitration agreement is not viable when the goods/service seller and consumers have an overall agreement on provision of goods/services that contain arbitration terms drafted by the seller, but the consumers refuse to have the dispute resolved by an arbitral tribunal. At Clause 12.3 of Vacation Ownership Contract, the parties agreed to choose the Singapore International Arbitration Centre (SAIC) as the agency and method of dispute settlement. Article 17 of the Law on Commercial Arbitration and Guidance in Clause 5, Article 4 of the Resolution No. January 2014/NQHDTP stipulates that the arbitration agreement is not viable when the goods or service seller and consumers have an overall agreement on provision of goods or services that contain arbitration terms drafted by the seller, but the consumers refuse to have the dispute resolved by an arbitral tribunal. It can be seen when considering the vacation ownership contract that the persons directly signed the contract as the representatives of V Tourist Company, Limited were Mr. Lehubi, Head of Finance Department of Representative Office of V Tourist Company, Limited, and Mr. Nguyen Hong S. and Mr. Nguyen T Long T. Mr. Lehubi was not the legal representative of V Tourist Company, Limited, and at the time of concluding the contract, the legal representative of V Tourist Company, Limited authorized Mr. Lehubi to sign contracts under the lawful order and procedures. According to the vacation ownership contract, the plaintiff bought the 16th-week vacation and the type of resort apartment was A. The time started from the year with the official opening date to the end of the project period. Mr. Nguyen Hong S. and Ms. Nguyen T Long T could sell or transfer to the others or exchange their vacation in some places in the world. Buyers had to pay in installments under the construction progress of the project. The official opening date was within 36 months from the date of the last construction permit issued and extended for another 6 months. Besides, since the official opening date, the customer must pay the maintenance fee or management fee annually. The parties entered into a free vacation ownership contract, a voluntary commitment, agreement, and content that did not violate the law's prohibitions, did not contravene the social ethics in effect for the parties, and must be respected by another subject and are the basis for dispute resolution. The trial panel found that, first, V Tourist Company Limited was granted an enterprise registration certificate, investment certificate to invest in and implement Almo Luxury Resort project in Con Hoa. Second, during the process of investing and implementing the project, V Tourist Company Limited held seminars to introduce the resort model in several localities, including Ho Chi Minh City. Third, the plaintiff was one of many customers invited by V Tourist Company Limited to participate in the event on February 26, 2017. Fourth, at the event, the plaintiff directly signed the vacation ownership contract with V Tourist Company, Ltd., and later on paid a deposit of 310,488,000 VND. And fifth, while waiting for the official opening date, the plaintiff said that the contract had many inappropriate provisions and repeatedly met the V Tourist Company Limited to negotiate the termination of the contract, but the agreement couldn't be reached. Therefore, the plaintiff filed a lawsuit. The trial panel considered that, first of all, it should be recognized that this is a new concept of ownership in Vietnam, in which the owner is allowed to exercise his or her rights for a certain period of time at the place where the vacation was purchased. The vacation ownership that Mr. Nguyen Hong S. and Ms. Nguyen T. Long T. deposited to reserve was considered a type of property, right, to be formed in the future. However, after the time of concluding the contract, only when the resort was officially put into use, was it owned by Mr. Nguyen Hong S. and Ms. Nguyen T. Long T. The plaintiff said that V Tourist Company, Limited, deceived the customers about the project owner and the investment capital. But through the documents provided by the defendant and publicly checked, it was shown that Company V has 02 capital contributors, including Company E, and Mr. Duong Tuan A. Company E was in the joint venture. Enterprises were controlled and owned by Mr. I and his businesses. Thus, that Mr. I was an investor of the company making investments through companies under his control was real. The plaintiff could not give evidence to prove that V Tourist Company, Limited, deceived them by asserting that Mr. I was the investor of the project. According to the plaintiff, the defendant advertised a product design which was an award-winning model, however, it was not built as such award-winning model. However, the issue of model design was accepted by the People's Committee of Con Hoa Province. There were no documents from the competent authority to cancel or revoke those advertisements and publications. When participating in the event and officially entering into a contract, the signatory must know about the event they participate in, the contract they sign, and the location they invest in. The location of Alma Nha Trang, where the tourist site was built, was publicized by the V Tourist Company, Limited, and shown on documents and transaction papers. There was no evidence showing that one of the contractual parties was deceived. Therefore, vacation ownership contract were valid. The provision in the contract providing the terms and conditions of resort rights were essentially the exchange of vacation ownership at the other resorts all over the world. This was an activity of the resort customers choosing an alternative opportunity from the range that exchange companies could offer. V Tourist Company, Limited did not bring Vietnamese abroad to travel, but only supported resort customers in connecting tourist destinations. That the company supported and assisted the customers in choosing a place to exchange vacations and support them in the procedures for other providers to provide resort services could not be considered a phase in bringing resort customers abroad, as the plaintiff argues. According to the vacation ownership contract, the amount paid by Mr. Nguyen Hong S. and Ms. Nguyen T. Long T. was a deposit. When and only after the official opening date was held did the paid amount become a part of the payment. Thus, the deposit of Mr. Nguyen Hong S. Ms. Nguyen T. Long T. was used for performing the contract as prescribed in Article 328 of the Civil Code 2015. The deposit amount received by V Tourist Company, Limited from the resort customers was decided by the company by investing in the project and paying for reasonable expenses not prohibited by law. There was no limit for the parties' agreement on the use of deposits. In the case of refunding or compensating for any reason, it was calculated the value of the amount to be returned and the amount of compensation. No one asked for being paid the exact amount of the deposited money as the plaintiff's claims. The plaintiff stated that, when entering into the contract, the marketing staff of V Tourist Company, Limited did not give the plaintiff a reasonable time to study the content of the contract. That was a violation of Article 17 of the Law on Protection of Consumers' Rights. However, spending time researching the contract was a consumer's right, that the plaintiff's failure to use this right was considered a waiver of his/her right. It is not stipulated in the Law on Protection of Consumers' Rights as well as the Civil Code that the contract is invalid in the case where organizations and individuals trading goods and services don't give their customers the reasonable time researching the contract. Therefore, the fact that the plaintiff voluntarily signed the contract was real. At the trial, on behalf of the plaintiff, the representative affirmed that the conclusion of the contract was completely voluntary. Therefore, the contract took effect. Regarding the progress of project implementation, the official opening date as determined under Article 8 of the contract was within 36 months from the date of issuing the last construction permit and extended for another 6 months, if any. The company would send the completion notice to the customers. Currently, there were 2 construction permits in the case file. Therefore, there was no basis to believe that V Tourist Company, Limited violated the construction progress, delayed putting the work into operation, and violated the deadline for handing over the vacation to the owners. From the above arguments and analysis, it was found that the vacation ownership contract and the attached appendices did not fall into the case of invalid civil transactions. Therefore, Article 131 of the Civil Code 2015 cannot be applied for handling the plaintiff's claims. For a request to return the deposit, considering the nature of the booking confirmation was a deposit contract. This deposit contract was not illegal and not contrary to social morality. The defendant did not violate the contract and the plaintiff did not have evidence to prove that the defendant violated the contract of deposit. Vacation ownership contract is not invalid as requested by the plaintiff, so the plaintiff's request to refund the deposit amount of 300,488,000 VND is unfounded. The decisions of the court are: to apply Articles 122, 123, 124, 125, 126, 127, 128, 129, 328, 401, and 513 of the Civil Code 2015, Article 14, Article 42, and Article 43 of the Law on Protection of the Interests of Consumers, Article 74 of the Law on Commercial, Article 17 of the Law on Commercial Arbitration, Section 4 of Chapter 4 of the Law on Tourism, and Article 147 and Article 273 of the Civil Procedure Code, to apply Clause 1 of Article 26, Clause 3 of Article 27 of Resolution No. 326/2016 UBTVQH14 dated December 30, 2016 regarding the rates of collection, exemption, reduction, payment, management and use of court costs and fees promulgated by the Standing Committee of the National Assembly. Disapproving of the requests of the plaintiff about declaring vacation ownership contract to be invalid and refunding the paid deposit amount of 300,488,000 VND because there was no ground. The content of case law is as follows. Vacation ownership contract number PBRCS 064621 fell into the type of model contract prepared by the service provider, prescribing the arbitration agreement. Then, the plaintiff, who is the consumer, disagreed with the selection of the arbitration and requests the People's Court of Nha Trang City to resolve the case under Article 38 of the Law on the Protection of Consumers' Rights, and Article 17 of the Law on Commercial Arbitration, which is guided by Clause 5. Article 4 of Resolution No. 01/2014/NQHDTP dated March 20, 2014 of the Council of Judges of the Supreme People's Court. Therefore, it was lawful and competent that the People's Court of Nha Trang City accepted and settled the dispute under Clause 3 of Article 26, Clause 1 of Article 35 of the Civil Procedure Code. The settlement of the case was still within the statute of limitations for lawsuits specified in Article 429 of Civil Code 2015. And Article 184 of the Civil Procedure Code. And that's the end of this video. Thank you for watching, and we'll see you on the next video of Learning Legal English through Case Law.